Section 200. This is the last section for today. Ratification cannot injure third person. An act done by one person on behalf of another without such other person's authority. We are talking of the same thing again. An act has been done by one person on behalf of another, but without that person's authority, which, if done with authority, would have the effect of subjecting a third person to damages, cannot by ratification be made to have such effect. So there can be no ratification in such a case. By ratification, you cannot cause injury to a third person. This is a limitation on the power of ratification. To understand this, let us take this illustration. A holds a lease from B, terminable on 3 months' notice. So a property belongs to B. He has given it on hire, on lease to A. And then this lease, to terminate this lease, to end this lease, a 3 months notice is required to be given. This notice must be given by B. And at the end of 3 months, the contract, the lease becomes terminable. Now instead of B, this notice is given by C. And C has not been authorized by B to give this notice. So C, who is an unauthorized person, gives notice of termination to A. And B comes to know of this notice after, let us say, 1 month, 2 months, 3 months. And B ratifies, saying that, okay, treat this notice as having been given by my authority. Section 200 says, no, it cannot be now ratified. The notice cannot be ratified by B so as to be binding on A. Because if it can be treated as having been ratified by B, then at the end of 3 months, A will have to vacate the premises. And that might cause an injury to A because it may put him to a loss. So by ratification, A cannot be put to an injury. And therefore, in such a situation, ratification is not permitted. The notice has to be issued either by B himself or by somebody on his authority. If the notice is originally unauthorized, then it cannot be subsequently ratified